Okay, it is exactly 7 o'clock p.m. Central Standard Time, and welcome to week number four. This is the fourth week. That means after this, we have 2 more weeks to go, and the course will be over. Seems like we just started, though, doesn't it? So I do want to comment that most of you did pretty well with the week 2 assignments. Um, Pay close attention to my points and comments about where you went wrong. It's important for you to pay attention to those remarks, but for the most part, you guys did pretty good. One of the things that you did not do is, I keep saying this whenever you deal with cases, court cases, and I say this in other classes, cite the original citation. The only time you shouldn't, if you can't find it, but in most cases, the cases that we used, you could have the original citations given. And I believe I included some of the original citations in the materials that I had given you the week before regarding exclusions to the warrantless search. So very important that you learn to keep that in mind, especially in my classes. Some professors may not think it, but it's very important. In the long run, you'll see why as you progress further on. So now let's move on. And I'm going to share my screen. Get out of that. Okay, let's go to Firefox. Oh, what happened to it? There it is. Oh, that's because, okay, let's take it. Let's take it out of here. Okay, now let's go back. Sharing. There we go. Okay. All right, so let's get into the course. And one of the first things I want to do is go over the calendar. And the reason is because this week will be the week that we have one lecture. You'll see what I mean in a few minutes. So your initial your initial discussion says it's due at 7 p.m. That's not true. Let me fix that. Let me fix that because it's not. Oops, let me go back to it. Back to the calendar because it's not 7 p.m. Oh, let's go back to the 26th. Okay, let's go down here. Here we go. There. Edit series. All right, so now I got that corrected. So now if you look at the month, yeah, well, before this, you know, it was here too also. Fix that. Show you how to do stuff here. Okay, so I saved that. Let's do the month again. So I got to come back because we started classes for that. You bear with me a minute here, even though it shouldn't because we're past that, but 'kay, that's all day. And I'm going to repeat it this time so that I can. Twelve. That should take care of it. Okay. So now there it is. Okay. Just a little cleanup work here. So anyway, this is where we are today, the live lecture. Initial post due tomorrow. Reply post due Saturday. And then the written assignment and live classroom lecture. Be aware that next Monday, we will have 2 lectures, week 5 and week 6. And just reminding you why that is, if you look at November, that's the first, you will see that I could have had week 5 there and week 6 here, but the class ends the next day. And as I said before, I made a decision to give you week 6 early in the week so that you can, and then I'll be talking about that as well. So you'll have the PowerPoints and everything for week 6, as well as I will give you the announcement, and you'll have the announcements for both of those weeks as well, so that you'll be straight there. But the course absolutely ends on the 9th. Okay, that's the last time I'm going to say that. I might say it next week again. So now let's look at the posted announcements for now. Week 4. We continue with one of my most interesting topics that as a defense lawyer that I like to deal with, and that is the Fourth and Fifth Amendment. Today we featured last week the Fourth Amendment, and as you already know, the Fourth Amendment has to do with unreasonable search and seizures, and we discussed the exceptions to the rule of obtaining a warrant. So this week we're going to deal with the Fifth Amendment and government authority, and chapters 4 and chapters 10 of the textbook. We're going to you're going to see the issues double jeopardy, which we'll talk about. There's some um, uh, articles as well that are in here. We're going to touch on just a little bit, but we're going to talk about double jeopardy, the right to remain silent, court case review, procedural due process, and then conclude with you looking at the knowledge check. Your initial post, right to remain silent, is due tomorrow night. Your reply post, of course, due Saturday, as I said, and then your written assignment. Fifth Amendment limitations due this Sunday, along with the key phrase. And you know about my motto, adversity is the springboard to success. Okay, so you can actually click on these. You'll see them in a minute in the module as we go forward. So that's the announcements for this week. Okay. So the topic, the Fifth Amendment and government authority. So let's talk about the written assignments first. So you up to speed on those. For this assignment, you'll discuss the limitations of the Fifth Amendment as it applies to real world scenario. And you're given this scenario. You're a relatively new detective and have successfully interviewed a few suspects over the past month. You are feeling quite confident in your ability to obtain ethical confessions. A battery suspect, Jim, has agreed to meet you at the police department. Once at the police department, he's escorted to an interview room. You explain he is not under arrest and free to go at any time. 20 minutes into the interview, Jim's mother arrives at the police department, demands you stop talking to him. Jim can hear her mom yelling, "Don't say anything to them." You continue the interview, and Jim makes some incriminating statements that put him at the battery scene and claims it was self-defense. Jim then requests to leave. You reply, "Well, no, you're under arrest for battery. You're no longer free to go." Very interesting scenario. Couple things in there. Number one, did Jim uh, voluntarily talk to the police? Yes or no? Did he voluntarily talk to the police? Remember, I'm going to ask questions. Type, give me the answers in the chat box. I'll see it. Did Jim voluntarily talk to the police? Samantha says yes. And so how do you know that? It says in your facts, a battery suspect named Jim agreed to meet at the police department. He's escorted. And you explain that he is not under arrest and free to go at any time. Okay. Now, Jim could have elected at that time to say, I want to go. However, what Jim decided to do, and Jim's 18, by the way, so he's not a minor, at least probably in most jurisdictions. Okay. So 20 minutes into the interview, his mother tells him to stop talking. You don't you ignore what the mom is saying. He's not a minor, and he makes some incriminating statements. That put him in the battery scene, and it claims self-defense. Jim then says he want to leave. He says, "Well, you can't leave now because you're under arrest for battery." Because at the time that Jim decides to talk, it says he makes some incriminating statements. That's the reason why the Fifth Amendment is there. As I have said many times to clients, excuse me one second. As I said many times to my criminal defense clients, it says you don't have to talk, the Fifth Amendment. And if you start to talk voluntarily, because you weren't in a custodial situation. Now, here's an argument that some people might try to make, and I can see it, but it's not very strong, that Jim was taken into an interview room, but he's told he's not under arrest and free to go. At that time, it was on Jim to test that out. Would you agree? Anybody agree? Well, no. When Jim was taken into the interview room and they explained he is not under arrest and free to go home, didn't Jim have the right then to test to see if he could go and not talk? That's my point. So they continue with the interview. Unfortunately, his mom gets there too late. He had already made some incriminating statements that put him in the battery scene, and it was self-defense. Then he requests to leave. Now, what they could have done, possibly an argument could be made, is that depending on Jim's level of intelligence, we don't know that. See, but we can't add facts here. But let's do this for just a moment here. I'm doing the lecture right now while we're talking about the assignment. Don't you think that if Jim had some issues, some um, some developmental issues, he had some comprehension issues in that case, then there might be a problem with them using that statement. You see a possibility that could come about, but we don't know that much about Jim. All we know is he's 18 years old and he's agreed to meet at the department. So they didn't go get him. He went on his own. Okay, and that happens. So when he said, by the time he says he's ready to go, he says, no, you're under arrest. Then what they should have done then was given him Miranda warnings, because if he made further statements after that, then um, they couldn't use those further statements. But they had enough information already. He had given them probable cause out of his own mouth, freely and voluntarily. Some might say, well, was he really in an environment where he really was really free in the questioning? How did it go? Fortunately, for many interviews and interrogations now, they're videotaped, so we could see the situation there. So be very careful about assuming certain facts. But I'm just saying they give you these points here to see how you can respond. So you're going to do it in a 2 to 3 page paper. Discuss when the right to remain silent applies in criminal cases. We're going to talk about that. Support your ideas with appropriate case law. If you do not cite Arizona versus Miranda and give the official United States Supreme Court citation, you will lose points. Telling you that up front, because it is the landmark case. It supports with ideas and appropriate case law. Explain how you would handle the demand by Jim's mother. I mean, there's a point. Describe how you would proceed, including how to properly handle Miranda when you continue to question Jim after arrest. I kind of already told you about that. Discuss how ensuring Jim's rights are protected is essential to procedural due process. Cite credible sources, include a reference page, use professional language, spelling, grammar, and punctuation. This is an interesting assignment. And then by the time we get through talking about this today, you will I enjoy these assignments. I said that last week, but this Fifth Amendment one. Okay, first of all, what column? Repeating sound like a broken record. What column? Yes, yes. Mastery, mastery. Okay. Believe it or not, some people tell off on themselves about paying attention to the lecture by not either find themselves not doing the proper amount of attention to what's being said while doing something else. Remember, the purpose of these lectures that I give is in place of you physically being in a class. So you need to conduct yourself the same way you would in the class as much as possible. I know you have distractions sometimes that happen, but don't try to multitask. Try to do other things at the same time, because you'll miss out. So mastery, as a horse do, put some blinders on so that all you can see is mastery. That's all I want you to see. So outstanding discussion when the right to remain silent applies, with comprehensive details supported by case law on the right to remain silent. Jim's mother's demand. An outstanding explanation of how you would handle the demand by Jim's mother, with comprehensive details as to how you would handle that. It's there. You'll find it. Miranda and protecting rights. Outstanding description of how you would proceed, including how to properly handle Miranda when you continue to question Jim after arrest, with comprehensive details on how ensuring Jim's rights are protected, essential to procedural due process. Then your credible sources, APA, and it must be, this is where some of you mess up, 2 to 3 pages. Now, if it says 2 to 3 and you give me 1.5, you're going to end up over here, which means you'll lose 50% of this right in here. You don't want that. So make sure you have the proper amount. And the reason why is not just to fill pages, but we believe that that's adequately how much it takes to adequately provide a response. This is an interesting assignment. You have plenty of material. It's not really that confusing. It can be tricky, but I try to help you out with that tonight during the lecture. Any questions about the written assignment so far? Any? Okay. I don't see anything said, so I guess not. Let's get to the discussion assignment of right to remain silent. The beautiful part about this module is that it sets out the stages for the topic that we are going to handle, starting at the very beginning with the title, The Fifth Amendment and Government Authority. So with the right to remain silent in the discussion post, you'll apply this scenario. You are a newly promoted detective on a burglary case where several ATMs were broken into over the past few weeks. Thousands of dollars have been taken. Surveillance video revealed a limited description of a male wearing all black clothing, including mask and gloves. The same trend pattern has been recovered from two different scenes. You have developed a suspect named Jim Davis. An anonymous tipster told you Jim is the one who has been committing the burglaries. You can't act on the tip alone and would like to have more information. So your detective supervisor has recommended you attempt a non-custodial interview with Jim. In your initial post, discuss the strategy you use to set up the non-custodial interview. We'll talk about that. What would you do to ensure it remain non-custodial? When might the interview transition from non-custodial to custodial? Discuss when the right to remain silent would and would not apply. Support your strategy and conclusions with constitutional case laws. Illinois versus Powell. I think that's the other one. I might be wrong. I think it's Illinois versus Powell. But the Illinois, of course, the Miranda case. But give me a second while I check something here, so I can tell you. Versus Powell. I think it might be the other way around. Oh yeah, yep, yeah. It's actually Powell versus the state of Illinois. That's the case, and you'll want to check that out. Yeah, that's my good old Chicago Heights case. But anyway, remember that one. I just gave you that one. And then in your reply post to at least one other student, examine the strategies and consider your application, the right to remain silent, and write whether you agree or disagree. Of course, initial post due tomorrow night to, so forth. So I'm not going to go into, I see some of you guys have already posted, and not going to tip off some others because they got to do their own, because remember, it's post first. All right. So let's talk about a few of these things. We're going to talk about double jeopardy, and then we're going to spend most of our time on right to remain silent and procedural due process. We'll deal with court case review and knowledge. So let's start out by talking about double jeopardy. So what exactly is double jeopardy? What amendment of the Constitution has to do with double jeopardy? Okay, I'm laughing. Yeah, but I said what amendment, and Samantha was right, and then Gress started elaborating on it. But yes, if you looked anywhere else, I said, remember what the topic is of tonight? So anyway, it means what Gress said. Means you cannot be charged for the same crime twice. Because here's what it says. It says the Fifth Amendment prohibits double jeopardy where it says, and there nor shall any person be subject for the same offense twice, put in jeopardy of life or limb. Can I ask you a question? Do you know if you're charged in state court, can you also be tried in federal court as well? Is that double jeopardy? Samantha says no, and she's correct. She's correct. She is correct. She is correct. Okay. It's very important that you understand that. And a lot of people don't understand that. How does that happen? It's not double jeopardy, but we'll hit upon that in a minute. So anyway, well, civil and criminal. Civil is different from going to civil cases generally are money damages. So, but the criminal cases are the ones I'm talking about. So a federal court case that's criminal and a state court case criminal. It can happen. It happens. It's happened many a times. And it's happened because there have been instances where individuals have, for example, I can tell you of in the 50s, some of the killings of civil rights workers, where the juries that heard the cases were for real juries of the peers of the parties, but they agreed to acquit the party, and they were their own people. So the federal government had to come in and right that wrong. I think the name of a movie, I think you'll see Mississippi Burning. I think that's one of the movies that has to do with the 3 civil rights workers who were killed. But there are other instances as well. You should be aware that that same thing is happening potentially in the Derek Chauvin case and in those police officers who were charged on state. And Derek Chauvin has already been found guilty, but can also be tried on the federal level as well. So, and sometimes people do that. They do that too because there is, for example, no death penalty in some state courts, but the federal would have it. So you got those kind of things. So it says this balance system requires the government to present legally obtained evidence that proves the accused committed the crime. And if the defendant is not guilty, they cannot be tried again for the same offense again in that court. Okay. Let's look at this double jeopardy situation a little further. Okay. Double jeopardy and juvenile offenders. Okay, this is a good way to be able to tell. Also applies to juvenile offenders who are tried for criminal offenses as a juvenile and then tried again for the same offense as an adult. This application of double jeopardy was created in Reed versus Jones in 1975, where this 17-year-old was determined by the judge to be delinquent for committing robbery. And then the court concluded that Jones was not a good fit for post-adjudication treatment and waived him to adult court. He objected to the waiver, the defendant did, and he agreed to have his case judged before the juvenile court record, and he was found guilty of robbery but committed back to the youth. Jones appealed to the United States Supreme Court and argued it was double jeopardy for him to be adjudicated in juvenile court and again in adult court. The Supreme Court unanimously agreed. Once you are adjudged delinquent, you cannot be tried for the same offense in adult court because that's state court again. That's not a different level. So it's very important. It's a basic thing, and so it applies to adults as well as juveniles. Um, and next, we're going to talk about the right to remain silent, which is going to be the big ticket for this. Now, if you want to look at a little bit more about double jeopardy, you can also see this. By the way, one of my favorite movies with a young lady by the name of Ashley Judd. You guys know who Ashley Judd is? Yeah, Ashley Judd is they're singers, but Ashley played in the movie. Um, yes, yes, yep, yep. You saw the movie Double Jeopardy? Yes, and remember what happened there. This kind of brings it home to you. Remember, she was set up by her husband and her quote best friend, and she ended up being found guilty of his murder, and she served time. She actually served time. She served time. So now it's discovered later that in reality he faked his death and he was with the lady. And then he got a new identity and moved to, I believe it was New Orleans. I think I'm right. Was it New Orleans, Louisiana? I think that's where he went. He ended up in New Orleans. And so anyway, you remember Tommy Lee Jones was her parole officer, and she got wind of him being there and found out. Well, anyway, the long and short of the story is that he tried to kill her. Remember that he placed her in a mausoleum with a dead body and all of that stuff. But she was a tough lady. She was tough. I guess being in prison helped make her tough. So she ended up reaching a point where she was able to confront him. And Tommy Lee Jones figured out what was going on, and they went after her to get her. Well, he tried to kill her, so he ended up getting killed by her and shot. So at the end of the story, two things. Number one, she was still his wife because the marriage was illegal and it was fraud, the person they were together in it. But she shot him to death. And so he was dead. And it was self-defense, but then she didn't even have to get tried for it because she had already been tried and convicted for the murder and served time. Therefore, they couldn't do it second time. And that's the essence of it. That's that's it. Awesome movie. If those of you out there who haven't seen the movie that are not in class tonight, go look at it. It's an awesome movie. I really enjoy watching it, even though I know how it's going to work. But I get angry about it too, as well. By the way, that is not how most double jeopardy cases operate, but that was an up close and very entertaining one. So you could check this link out. Let me make sure it's working because I always check these links out to see if they're working. I think this one is, yeah. Okay. All right. This one is um, 1 minute and 27 seconds, and it gives the meaning and explanation of it. So you can check that out yourself as well. I think, let's see if I see right. I'm trying to look at the corner. Uh, I thought this was also one that had the notes in here about, um, but anyway, that's what it is. That's what double jeopardy is. Okay. Any questions about double jeopardy? The name kind of like explains it, but a lot of people know this even before they even take this class. And then this is something for you that I'm not going to spend time, but I'm just pointing it out, just checking to see if the link's working, because it did work before. If you do find a link that's not working, bring it to my attention, please. Two defined double jeopardy cases, and you can take a look at these two cases as well. Okay. By the way, the double jeopardy information is not so critical to your written assignments, whether it's the discussion post or either the this discussion post or either written assignment. But this is just good information because it's in the Fifth Amendment as well. That's why. So now let's get to the meat, as I call the main course. Very cute. Whoever put this in here, it means what it says. Uh, don't talk. Do not talk. Okay, and so uh, it's quite important that you understand that, do I have the right to remain silent? You know that because the Fifth Amendment tells you, because what you can say can incriminate you. Are you aware of individuals who are even testifying in cases or before a sworn committee like the congressional committees? They can plead the Fifth Amendment, which means they don't have to testify. However, there is a way to get them still to testify if they plead the Fifth. Does anybody know the answer to that question? I'm going to tell you, but do you know? Something that the prosecution can do. Do you know what that is? They can do something. No, it doesn't have to do with marriage. Any other guesses? How about granting immunity? Have you ever heard that before? Nope. Okay, I'm going to tell you, Samantha. What that means, they have a thing that's called use immunity, USE immunity. And in use immunity, what that means is the information that you testify can be valuable for us because they'll use that oftentimes to get somebody else. And that means then that person can testify about something bad they did that could lead to the big fish. It's used a lot in mob cases, a whole lot, where that person is granted use. It's called use, and the reason it's called use immunity is because it's used for purposes of granting immunity to that person that person wants. And actually, the prosecution makes the decision that that's not really who they want. They just want information. Like, I'll use the parallel for what's happening right now, but it's not court, but it's a congressional, where a legal document called a subpoena has been issued on Steve Bannon. Steve Bannon says, I'm not coming. Steve Bannon comes and he says, I'm not going to testify. And Steve Bannon, why aren't you going to testify? He says, because I'm pleading the Fifth. Pleading the Fifth. You've heard people say pleading the Fifth before, Samantha, haven't you? You've heard that before? Yeah, well, people do it. Welcome to the criminal world. It originates from the language of the Fifth Amendment. You don't have to self-incriminate. Coming from his mouth, that's self-incrimination. And you don't have to do that. You don't have to do that. That's what we learned earlier about that young man and his mom came. You don't have to do that. That's why we defense lawyers would tell our clients, don't talk to the police. Because that Fifth Amendment right, it's constitutional. That's where Miranda stemmed from. So the answer is you don't have to talk. Okay. So you've obtained enough information from the suspect to establish probable cause, and he is no longer free to go. So then at that point, do the Miranda rights apply? Yes. Yes. During the interview, the suspect's mother arrives at the police station lobby and demands the police recognize her son's right to remain silent. What is your response to her? And you're going to remember that sound like a written assignment? It is. Well, most Americans are familiar with the right to remain silent, and you have the right to an attorney established from 1966, Miranda versus Arizona. Shame on them. Shame on them. I'm saying them who put this together. It should say Miranda versus Arizona, and then the case number, and then it should end with the parentheses for the year. It says, although the rights are well known, the application of rights is often misunderstood. So we're going to talk a little bit about that. Okay. The right to an attorney comes at another time. That's the Sixth Amendment, but it's in here. It's in here. So let's look at the Miranda rights, which we don't have to spend a whole lot of time on because of the fact that almost everybody knows about it. And so what happens is these rights were carved out of an individual by the name of Ernesto Miranda, a case that was handed down by the Supreme Court in 1966, where he had given a written statement and was convicted. And the state court said yes, because Miranda never requested an attorney. The Supreme Court reversed and cited the advisement of the Fifth Amendment were necessary safeguards. So the Miranda rights were born and have been applied and examined by the courts since that time. And it's very well known. Just saying them offhand, you have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. Then they ask if you cannot afford an attorney, one would be provided. That's another part. But here's the right to remain silent part. And so the Miranda rights are more than safeguards. They're part of the constitutional fabric, according to Dickerson, which I told you is based on the Fifth Amendment itself. Now, it only applies to one who is in custody. The question, that young man that came in voluntarily to the police station, was he in custody when he came into that police station? He could have been, but you're right. He was explicitly told that he was not in custody and that he was free to go. Here's the deal, and it's written right here, but I say it all the time to my students. Well, first I'll ask this question. In order for a person to be under arrest, do you have to use the words under arrest? Samantha says no. What about you, Grace? You said probably. First you said no. So which one is it? I have said, okay, so your answer is yes. Yes to what? Yes to what? That you have to say that you're under arrest? Wrong, wrong, wrong. That's how people mess up in multiple choice exams. The key that you're going to discover is when the liberty of a person is taken away. At that point in time, they're under arrest. Okay? Look at what it says here. It says Miranda rights apply only when in custody, under arrest, which may be using the words you are under arrest. But the test is an objective test applied and often hinges on the degree of restraint. And if a reasonable person would be believed they were not free to go. That's the answer. So if you are surrounded by, yes, it does. Yeah. But the point of the matter is that you don't have to say that. You're under arrest. You know, you have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. Tell me where the Miranda right says the words arrest. I'm going to pull them up for you. Just a second. Because it's usually now given on a prepaid card. Okay, I'm going to give it to you. Here we go. I got it in my notes. Okay, here's the script. Here it is right here. You have the right to remain silent. Anything you can say will be used against you in the court of law. You have the right to talk to a lawyer and have one present. If you cannot afford one, a lawyer will be appointed for you. 5, you can decide at any time to exercise these rights and not answer. A waiver. Do you understand these rights? Did you hear the word arrest in there anywhere? That's why people see they get confused. And so remember what I'm telling you. If you took criminal law with me, I talked about that. Very important when it comes to Miranda. And something I need to tell you about Miranda, I think I've said it before in other classes, but you might not know because if you weren't in any of my other classes, that my law professor that I had by the name of Fred Enbow, he was together with a guy named John Reed, who wrote a book, Interrogation and Confessions, were the techniques that were used by the police in interrogating Ernesto Miranda. And that's the techniques that they were trained upon to use. And the Supreme Court says, no, these warnings are not good. And these things are not good. Therefore, we're going to give something to neutralize that. And thus came the Miranda warnings. My professor felt personally maligned. He told us that in law school in 75, in my first year. And I had some inside knowledge about that. And every year, whenever a Miranda case came up, he filed briefs. He's passed away since then. So I know, as they say, from the horse's mouth about how my professor felt about that. So therefore, if a person has been arrested, but the police do not wish to question them, then the Miranda warning is not required. Okay? It says fictional law enforcement stories often depict police immediately reading a Miranda warning upon arrest. That's not necessarily true. Immediate advisement is unnecessary unless the police want to ask questions. Now, the key thing is that police are often trained by given a card to read because you'll be asked about that in court. And I have cross-examined individuals about the Miranda warnings, and they had to give them properly. But once that person is under arrest, then you probably want to interrogate. So you might as well give the warnings even if you don't question them, but at least you're covering yourself as a law enforcement officer, and that stuff that comes out, statements that come out, can and will be used against that individual. Does that make sense? Okay. So now you learned something today, that the word arrest is not there. Nope. And you said, dang, all these years, I thought it was. Nope, not there. Failing to properly advise an arrested person can result in confessions gathered being excluded under remember the exclusionary rule from last week. Same thing here. The right to remain silent is the first part of the advisement, um, and that's what we're going to take a look at primarily. So if a person arrested is subject to interrogation and wishes to remain silent, it tells you quite clear that a suspect who voluntarily comes to a police department for questioning is not under arrest and cannot assert their right to silence. There's the case right there. Pay attention. That's Elena's case. I already knew that, but I wanted you to get to that here. And you said, oh, when a suspect invokes the right to remain silent, it must be clearly expressed. Merely remaining silent is not enough. You got to say it. I don't want to talk to you anymore. Okay? And oftentimes now departments have developed what we call written waivers to demonstrate people understand their rights. But of course, if they can't read, then we got a point. The right to silence is a personal right and cannot be asserted on an arrested person's behalf. Does that answer a question that you had about your discussion and the boy's mother? Smiling because it should. Does it? Yeah, okay. Mrs. So-and-so, so-and-so cannot assert on behalf of her son, according to People versus Houston, 2012, and State versus Corporate, 1996. Well, the 1996 was first. So the key thing is that when the right to silence is expressed, questioning should stop. You can't go back to that person and try later. They can't change their mind. If a suspect reapproaches police and desires to talk, this suspect reiterated contact permit law enforcement to question the suspect, presuming they read a fresh Miranda warning. So that person comes back, which hardly ever happens. With the videotaping and taping now, you have proof of that. So the right to remain silent, along with the right to an attorney, which is the Sixth Amendment, included in this for individuals who are in custody and subjected to interrogation. And it is important. Failing to honor a clear and unambiguous expression, remain silent, can result in evidence being subjected back to what I said earlier, the exclusionary rule. So the statement cannot be used. By the way, see the official citations here? This is what I was talking about. These are what I'll be looking for. This right here, this stuff. You got it right there. Okay. Everybody should be quite clear on the Fifth Amendment, and we're dealing with double jeopardy, but primarily the right to remain silent and when and how it works. Any questions about it? What about the Fifth Amendment? What about it? Any questions about it? Accident. Okay. That's the bad part about people not being able to speak, is that That's why I don't like emails responding to things. I like text messages where I can talk to you because we can lose a lot in that. So, all right, I got you. Okay. So the court case review, I'm not going to spend a lot of time. We're at our stop point, but anyway. So this tells you, you know, about some cases and things that you are familiar with. Choose the correct answer. Which case established the right to remain silent? If you don't get that one, you fail the course. Correct. Which case established that an individual cannot assert the right to silence when being voluntarily questioned? You say that? That's what you want to say? Wrong. Remember the Salinas case? We just got through talking about that. Remember that? I just that's how you do on a test. You fake yourself out. Okay. So anyway, I'm not going to keep going with that. But these are things that can help you there with that. Procedural due process is that you have a right to the hearing and not deprived of life, liberty, or pursuit of happiness without an opportunity to defend yourself. The Supreme Court deals with this straight up. Federal due process. So these are the things that go with due process, pretty much. A hearing must occur. Notice of the action. An opportunity to present reasons why uh, the actions were brought. The right to call witnesses on your behalf as well. Right to an attorney. That's that Sixth Amendment. A record of the hearing is made. That's what we call the court reporter. You see the person, stenographer. A written statement of reasons for the decision and public attendance. And public attendance. When is there a court that you don't have public attendance? Anybody know? That doesn't. Yeah, minors family. But what do you call that? How about juvenile court? Okay, well, but you had the right idea. Okay. All right. And then here's your knowledge check yourselves again to help you to learn more about this stuff. And you go through the knowledge check. Which amendment prohibits double jeopardy? Yeah. Some people might think this one does, but it does not. That's cruel and unusual punishment. This is the right to an attorney. This is search and seizure. This is it. You're right. The Fourth Amendment protects against search and seizure. The Sixth, right to counsel and other things. So, okay. So anyway, I want you can go through those yourself as well. A little knowledge check stuff. Good things for you to do. Okay. I am done. Any questions? How about taking a shot at it? That's pretty good. Be more specific. Well, that's broad. How about right to remain silent is the topic, but how do we know about it? No, that has nothing to do with right to remain silent. That's being tried twice. As soon as I say this, you'll get it. It's the name of a case. Okay. Yes, that's part of it. All right. The rights is the name of the case. How about Miranda versus Arizona? That's what I want. Don't give me part of it. So I think I tipped my hand at the very beginning, but yeah, you were right about the theory, but I wanted you. Remember, I said at the beginning that you must, if you're going to deal with this, cite this case. Didn't I say that? Yes, I know. I set you up there. So, but that's it. Give that to me, and I promise you, somebody's going to send me a message and say, Professor Wright, I didn't get the key phrase. You didn't say what it was. I did, and I'm not going to say it again. Okay, you know what it is. So put that in there, get your points. And just remember too, when you do utilize the case for proper citation, you should already have that. I would have written that down, or either I said, oh, I know where to find it. Professor showed us. Okay, guys, good night. I will see you next week. Remember, next week is week 5. Um, Yeah, but that would have been double jeopardy. That wasn't the essence of. Now you know me by now, Samantha. You know that my topics have to do with the overall theme of the big issues. Do the written assignments have anything to do with double jeopardy? Okay, you answered your own question. No, but still, go to law school. Go to law school, like that's where you can present those points. You know? But the final ruling is, with the gavel. It is what I told you. That's it. Okay. LOL, LOL, LOL. See you next week. Again, remember, next week we'll have hard stop at 9 and at 8. I mean at 9 at 8 o'clock. I mean at 9 o'clock. 8 o'clock. 8 o'clock. And then we'll have a half-hour break and we'll come back and do the second one. Okay. That would have been funny. See you next week. Okay. Good night.